name case which is from the district involved.
सब रिकॉर्डेड प्रोसीडिंग में हम लोग इस तरह से नहीं कर सकते ना. वी डू नॉट नो कौन आदमी कहाँ से क्या देख रहा है. इस तरह से हम लोग ऑलरेडी नहीं कर सकते.
Also case item 26, second April 57 of 2023.
Yes.
One day it may be listed on Monday as the first.
सब लोग कोई और थे.
नहीं,
आप तो नहीं थे.
हम ही थे. एक और साथ में आए थे.
नहीं. Somebody else was appearing on.
नहीं, I was there also.
You were there side में.
नहीं, मैं ही थे.
जिनको हम बोल रहे थे फाइल नहीं मिलता पढ़ने के लिए. तो
अभी को बोल रहा था.
ना.
मेरे साथ में एक और आया था.
कोई और थे ना. नहीं थे. कल से छुट्टी है क्या? At the request of the learned counsel for the appellant, let this matter be posted tomorrow by way of last intelligence.
मंडे का 2 दिन का टाइम मिल जाता है.
अभी डिसमिस कर. अभी छुट्टी खत्म हुई 1 हफ्ता भी नहीं. फ्राइडे से छुट्टी बनाना शुरू कर.
वैसे वो पर्सनल मीटिंग होती है.
For finalists for item 1, second April 402 of 2016, looking at item 2.
There are 2 appeals. The appeal number 393 of 2016 is with regard to Schedule B property, where there is a concurrent finding by both the courts below.
This is with regard to Schedule B.
Schedule. And partition suit was filed and the defendant. Suit was decreed. Appeal against that has been dismissed. And as regards the other appeal, that is appeal number 402. Of 2016. In this, Your Lordship, this is related to Schedule C property, where the trial court held that this was individual property of the persons, and therefore this was.
I don't understand. The same defendant is filing 2 appeals arising out of the same judgment.
No, because the original suit was the trial court what it did. It allowed partition only with regard to Schedule B. With regard to Schedule C, it held that it was not participable because the plaintiffs had failed to prove that there was any nucleus. It had been purchased from outside.
So Schedule B and Schedule C were subject matter of the same suit.
Same suit.
So
But,
why two different appeals?
Yes, I'll come. Because with regard to Schedule B, the partition was allowed, so we preferred appeal. In that itself, a cross appeal was filed by the other side because their claim of partition with regard to Schedule C had been denied by the trial court.
That's
And therefore they filed a cross appeal which has been allowed. So basically with regard to Schedule B property, my appeal has been dismissed, and with regard to the cross appeal with related to
What
Schedule
was the
C,
number of cross appeal?
yes. In the same appeal, the Lordship cross appeal had been filed.
Has
I
it been
could not
separately
get
numbered?
that. No, it was not separately registered, but in the same appeal, it was
Just a
recorded
minute.
as cross
Just a
appeal.
minute. Essay number 402 of 2016 with essay number 393 of 2016. The learned counsel for the appellant has submitted that so far as essay number 393 of 2016 is concerned, the same is dealing only with Schedule B property, and the suit was decreed for partition in connection with Schedule B property, and the defendant's appeal has been dismissed.
Yes.
So far as appeal number 402 of 2016 is concerned, he submits that the prayer for partition with regard to Schedule C property was declined by the learned trial court, and upon cross appeal by the plaintiff, the same was allowed, and therefore the defendant is in appeal in connection with Schedule C property in appeal number 402 of 2016. That's right.
If one by one I'll take both the appeals, Your Lordship,
Yes.
Otherwise it would be confusing. The genealogy is not in dispute. Any of the file Your Lordship may take up because
We'll take up Schedule B first.
yes. Schedule B. That's in that the question of law is, I'll not go into detailed facts, Your Lordship. Absolutely question of law which is involved. The 393 of 2016, the question of law, this is with regard to Schedule B, and the question of law that was framed was whether the courts would have misconstrued Section 18 of Hindu Succession Act while dealing with the law of succession regarding inheritance of property of Hindu. So,
Schedule B against, okay, which is order dated?
order dated 31/3/2022.
31/3/2020. I just got it wrong. Let this 402 be taken up first.
Yes.
The reason being that 402 must have given a finding regarding unity of title and possession. Then the owners will shift accordingly.
No, because in the common judgment it has been passed. It, both the trial court and the appellate court has also dealt with in the same judgment itself. So therefore it is a one judgment which
Can
is.
we take up 402
Yes,
with regard to
absolutely,
schedule?
absolutely.
This is with regard to schedule C.
C
property.
property. Yes, absolutely. Your Lordship may take it up. Either way it would come to the same.
Okay.
But Your Lordship, I would clarify everything. Absolutely. If Your Lordship would take up.
Okay, let's take 393. Let's continue with 393. This section 18 of Hindu Succession Act.
Yes. Section 18, what it says, if Your Lordship would
Hindu
first see,
Succession
then we'll go to,
Hindu
because
Succession Act.
And simultaneously, if your lordship would take up
First read the section.
simultaneously, if your lordship would take up the genealogy which is there, because without looking into the genealogy, your lordship, it is there in running page 61. That means it was a part of the trial court decree.
Running page 61.
61. It is a part of the decree itself. Decree passed by the trial court. And page
Running page 61 is giving the list of exhibits.
if your lordship would take out the decree of the original suit, in that
Genealogy is where? Yes, it is in 66th page. Internal page 3.
yes, there is a genealogy, very clear. Only top line it would make it absolutely everything.
Yes.
Gudrugo had 2 wives. From first wife he had 3 sons. That is Girdhari, Gundu and Mithu.
Yes.
And from the second wife, Bholagop was there. Now the plaintiff respondents herein are the sons of the Bholagop. That means from the second wife,
Okay.
Bholagop was the
Just for worship permission, I want to say that the property is not a state property of the female.
Sorry?
This property your worship is of Gudrugo. He had 2 wives.
Let him address.
Yes. So the provision of law which you want to contest your worship. That very provision itself says, heirs related to an intestate. The lordship may complete will have to see section
not yet
16.
completed. I have yet started my argument. This is absolutely unfair.
Yes.
Your lordship, he had 2 sons, 2 wives.
They are governed by Hindu law?
Yes, absolutely, no doubt about it.
Again.
So there are 2 things. A question may arise whether it was prior to 56, nothing has come.
We'll take care.
But then also, they are Hindus, and even if they are governed by Hindu Succession Act or even prior to that, in both cases, same principle would apply, same principle.
Let's see.
Yes. What is that also? That means Gudrugo had 2 wives. That was first wife, the 3 sons were there. From second wife, Bholagop was there, and Bholagop had 3 sons who are the plaintiff.
That's right.
Now, from first wife there were 3 sons. 2 of them die issueless. So what would happen? The only question is, what would happen to the properties which were which had devolved on Gundu Gop and Mithu Gop? Whether it would go to Girdhari Gop or it would also go to Bholagop. This is the only question. Now, our contention.
Let me just.
Yes.
You see, this is Gudrugo,
Yes.
2 wives.
Yes.
So there is one
Property belonged to
Girdhari
Gudrugo. Property
Yes.
belonged to Gudrugo. This.
Okay.
Yes.
Now, under normal circumstances,
Yes.
the children of a second wife, they are entitled to a share in the property.
Yes.
Right? There is no doubt on that.
No, after 56 it may be in question, but this has not come in our case.
Okay. They are entitled to equal share.
Yes.
Right? So, after death of the first wife, there cannot be any equitable distribution between first wife and second wife.
No.
There is no question.
No.
Right. So, if all these children were alive,
Yes.
then the property would have devolved equally amongst each one of them.
Yes. That is their case. That is their
4,
case.
5, 6,
Yes.
7.
That is their case.
1/7 share,
Yes.
right? If 2 persons amongst 7, they died without partition, or maybe 3 of them died without partition, then under such circumstances, the entire property will devolve upon remaining 4.
No, that is the question. Therefore, I said, Your Lordship, in the plaint itself, what has been mentioned, and we have also stated the same thing, that Kudrugo, here both the parties have not stated whether the wives also got a share or not. Only question what the plaintiff said, and we also repeated, was Gudrugo, the property had been acquired by Gudrugo. He had 4 sons, and each of them had 1/4. The property devolved, Gudrugo, after his death, devolved on his 4 sons, and after such devolution, Hondugo and Mithugo, they died issueless. So here the dispute is not whether first wife or second wife would get or not. What would happen to the 1/4 share which had devolved on Mithugo, whether Mithugo and Hondugo, whether it would go solely to Gedharigo or it would go to Bholago also. This is the only question. Now my contention is that Your Lordship may kindly see section 18, and then I'll show the old Mitakshara law which is there also. Now Your Lordship may kindly take up section 18 of the Hindu succession, because that directly answers the entire question.
Okay, section 18.
It says that whenever a question of devolution would come, the property would, the full blood would be preferred over the half blood. My apologies, Your Lordship. I have brought the Hindu law, but the Mullah's Hindu law. Yes. It says full blood preferred over the half blood. Heirs related to an intestate by full blood shall be preferred to heirs related by half blood if the nature of relationship is same in every aspect. So here the question was that plaintiff himself says in his plaint that Gudrugo died leaving behind his 4 sons. The property devolved on his 4 sons, and then the other 2 sons, they died issueless. This is very clear statement of the plaintiff in his plaint itself. So when the persons who die issueless, then in terms of section 18, the full blood would be preferred, and the 4th son, that means the 4th son would be considered to be half blood, because his relationship is equal in all aspects, but the property would go to the full blood, not to the half.
So 3/4 to Bidharigo
Yes.
and 1/4 to Bholago.
Yes.
According to you.
Absolutely. This is my only question. Because very clear section 18 says that whenever all the relations are same, then the full blood would be preferred over the half blood if all the other relations are same. So they may be brother, but he is the step brother. So own brother, full blood brother would be preferred over the half blood brother whenever the question of inheritance would come. So now, Your Lordship, I'll take to let us assume that this had occurred prior to 1956. What was the original Hindu law? Now, original Hindu law, if Your Lordship would take.
You see, had these 2 wives
Yes.
were 2 sons, had these 2 were 2 sons instead of 2 wives, then under such circumstances, your contention that it will devolve to full blood in preference to half blood is correct. But technically the law is the property is not devolving upon second wife at all.
Here, both the parties are not at issue whether the property would go to the wives or not, 2 wives or not. What would happen to the properties of the 2 persons who had died issueless? if there was no, so therefore section 18 would apply. So what would happen to their properties, to whom they would go? So
And maybe that it is also not clear as to whether the wives had predeceased Gudrugo
nothing has come.
or when did
No,
they die.
their question.
Their date of death of Gudrugo
No,
and
no,
date
it
of
has-
date of
it
wives
has
is
not.
also not there.
Subject to correction. It has
Because
not.
there could be a situation that both the wives died before Gudrugo.
It may be, but it has not come.
But
as
it
to
has
what
not
would
come
happen.
because parties did
So-
not join issue on that.
Yes, yes. The parties are absolutely clear that the, now what they say, now the plaintiff says that after the death of the two sons, that means who had died issueless, there we had 8 annas of over the entire property and they had 8 annas,
50-50.
50-50 because
Half-half.
half over the entire property.
Yeah, it will get distributed amongst the surviving heirs.
Yes, this is the,
This will go by survivorship.
yes. And if whether I have disputed or not, this is absolutely a question of law, which is there, which is very clear from perusal of section 18. And your Lordship may kindly take up the original Hindu law, Mullah's Hindu law, which is there. This your Lordship may kindly take up. What would happen to order of inheritance when the question of Mitakshara family is concerned?
Do we need to refer to the old Hindu law? Do we need to refer to the Mitakshara law?
In case
Is there any difference between the Mitakshara law and the Succession Act?
no, I just wanted to point out exactly same provision was there even prior to 1956 also. Therefore, only to that extent the law was same. It was only by way of a statute this particular provision was brought into
Recognized.
section 18. So this is the only portion
What do
I'm
you want to
just
say? Order of
pointing out.
succession.
Your Lordship may see, I've folded a page in your Lordship's book.
149.
Yes. From that it starts, and the flagged portion is when the brothers are in question,
Yes.
then what would happen? Brother of a whole blood, there are two portions. Brother of a whole blood, brother of a half blood, whole blood before half blood. Brother of the whole blood succeed before those of a half blood. The half brothers referred to here are the sons of the same father but different mother. So here also the same question is there. I am not referring to other because he says sons of the same mother by different father are not entitled to succeed. So this portion I am not relying on. I am only relying on the first portion which very clearly says that brothers of the whole blood succeed before those of the half blood. The half brothers referred to here are the sons of the same father by different. Exactly same situation is. So therefore my contention would be that once the two persons, that means two sons of
ये दो जजमेंट बनाइए तो AIR 1966 कोलकाता, Calcutta, 447 and 1972 Odisha, 153. Calcutta and Odisha basically
probably I
were
have
governed by the
taken out a copy, but I got a recent judgment where division bench of Calcutta High Court had dealt with this issue and substantial reproduction of the same Hindu law, and it was very clearly held that it was nothing, section 18 was nothing but a substantial recognition of the already
That's-
existing provision.
It does not bring out a change.
No,
It
This
is not
was-
a change in law. Basically, this Hindu Succession Act is codification of substantial law which was already existing
already existing.
with certain modifications,
Certain modification.
particularly with respect to right of women to work.
Yes. Because prior to 1956, there were limited right that was converted into an absolute right. That was the
So this is
So-
now let us see the findings on this.
yes.
So the court has given 1/4,
Court has given yes. Court has divided half in half.
half
To
and
both
half. Sorry,
the-
yes.
yes.
Court
Yeah.
has divided
Although
half
it-
and half, and you claim that it will be 3/4 and 1/4.
Yes. The
This is the only
plaintiff suit with regard to 1/4 only could have been decreed. This was my
What was their claim?
their
Claim
claim
was
was half and half.
half.
because they say that only 2 sons were surviving and therefore,
Let us see the findings.
yes.
First, the trial court.
So first,
This is relating to issue number.
in trial court, Your Lordship, this issue was not raised that they are entitled to.
Let us see the
I'll
issues
show
framed.
that also. I'll show.
Let us see the issues.
What I had said, that Your Lordship, we had denied the partition in toto. We had said that they were not entitled to any share because there were earlier litigation also, there was previous partition, and therefore they were not entitled to. So that was negated. And Your Lordship, I must also concede to the fact that there we were relying on a partition compromise decree of the year 1938. After that, there was a record of right was, so we had challenged that in a subsequent suit that record of right was not, entries in record of right was not correct. Then what happened that we filed a suit challenging the entries of record of right, basing our claim on the basis of a previous compromise decree which had ended into a compromise decree. So that was initially dismissed by the trial court. We went in appeal. In 1970 that was filed. We went in appeal. In appeal, the appeal was also dismissed, but when second appeal was preferred, second appeal appellate court, that means High Court, it remanded, set aside the first appellate court order and it remanded the matter back to the first appellate court. Thereafter, the appellant did not pursue. That means we did not pursue and the matter was dismissed from the court. So our contention was, despite that, the previous partition had been proved and therefore they were not entitled to. But I have not. That
Let's
is not a
forget it.
question. Only for the purpose of full disclosure.
We'll confine to the niche question of law which has
Yes,
been
yes.
framed.
Why
We will not move
only with
anywhere.
regard to full disclosure?
You see, it is not a regular
So here
appeal.
the question would be that despite such adverse, the only effect was that the properties
Let us-
remain joint.
Let us take it
Yes,
that the properties are joint.
yes,
Secondly, the fight is only with regard to the proportion of shares.
yes, yes. What would happen to the properties which had ultimately devolved on the persons
That's
whose
right.
sons, to
That's
whom it would go? That is the only question.
Now, in the trial court's judgment, we find issue number 10, error number 25, internal page 9, issue number 10.
It starts from,
Let me just capture it, just
Yes.
a moment. लिखिए sir. The learned counsel for the appellant, with respect to the first substantial question of law regarding appreciation of provision of section 18 of the Hindu Succession Act, has referred to the undisputed genealogy on record, which also forms a part of the decree passed by the learned trial court, and has submitted that it is not in dispute that the property schedule B
schedule B.
or schedule पूरा ही
No, schedule B.
property in schedule B was recorded in the name of Gudru Go,
Were acquired by.
was acquired by Gudru Go, and he had 2 wives.
Yes.
First wife had 3 children, including Gidhari Go. The remaining 2 died issueless. So far as second wife is concerned, she had only 1 child, namely Bhola Go. The partition suit was fought by the 3 daughters.
No, all sons. All sons.
That Bhola Go had 4 sons, and one of the sons died issueless, and 3 sons were the plaintiff in the suit, claiming property through Bhulago.
3 children your lordship mentioned because
Children
I'm not
Bhulago
sure
and नाम से कुछ
like
ऐसा।
whether Rima is a
4 children लिखिएगा. 1 died issueless and 3 remaining children of Bhulago were the plaintiffs, and they were claiming the property which stood devolved upon Bhulago.
yes.
Girdhari Gop and his name, the legal heirs and successors of Girdhari Gop were the defendants. He submits that the court has partitioned the suit in the ratio of half and half between the 2 branches of Girdhari Gop and Bhulago.
Yes.
The learned counsel has submitted that that the property stood devolved equally amongst 4 sons of Budrugo, and upon death of 2 full brothers of Girdhari Gop, their share would have devolved upon the branch of Girdhari Gop.
Yes.
And consequently, the property ought to have been divided in the ratio of 3/4 to 1/4
Yes.
with respect to the branch of Girdhari Gop and Bhulago.
Yes.
But the learned court has wrongly divided the share half.
Ah, this is
He submits that for this purpose, section 18 of the Hindu Succession Act would be relevant. And while referring to the said section, he has submitted that heirs related to an intestate by full brothers is to be preferred as compared to the heirs related by half blood,
yes.
full blood and half blood. The learned counsel has also referred to the book Mullah on Hindu Law, 21st edition, at page number 149, to submit that the law that whole blood would be preferred to half blood was already in existence even prior to Hindu Succession Act came into force in 1956, and such provision under section 18 is in recognition of, is basically codifying the earlier existing law with respect to this aspect of the matter. And he submits that the impugned judgment dividing half and half share between the Girdhari Gop and Bhulago
Bhula.
and Bhulago is not in accordance with law. It should have been 3/4 and 1.
Yes.
Okay?
And last line. If your lordship would take up that same old Hindu law, 3-4 pages before that, only one line I am showing. Propinquity, the governing factor. Its heading is 36. 36. And it says, the under mitakshara, the right to inherit arises from propinquity, that is proximity of relationship. This is very important. So,
Where do I see page number?
3-4 pages before that folded portion are
This has been folded, but maybe this side. Adopted son.
or one page before.
Daughter, son, mother.
One or two pages before your lordship, the
थोड़ा आप
folded
लिख के
portion.
बताएंगे?
Folded portion. I'll take it out. I'll just.
इनको पेंसिल देंगे थोड़ा सा. Yeah, ये book.
नहीं,
maximum.
We have open the 36. At the top of that page, you would find 36.
Yes.
It says that the entire Mitakshara law, the right to inherit arises from propinquity, that is proximity of relation. So this line is very important. Now if whenever the question of inheritance would come to the properties of the two deceased brother, the full blood brother would be closer to the step brother.
The Learned Council has also referred to page 103 of the same book. 103 133 of the same book, which deals with propinquity being the governing factor under Mistakshara law, and he submits that it has been stated therein that right to inherit arises from propinquity, that is proximity of relationship. He submits that the proximity of relationship with respect to full brother would be more closer, full blood brother would be closer to than that of half blood brother, and therefore upon death of full brothers, their share would have devolved upon full blood brother and not upon half blood brother. Okay. Now let us see the findings.
Yes. Ultimate finding is at page paragraph
For
44.
this para number 25, we have seen as to whether they are entitled to half and half share. Issue number 10, para 25 of the trial court judgment. Then admitted facts has been mentioned in para 27.
Yes. And then issue number 8 is unity of title and possession.
Then where is the share? Discussion of the share of the estate.
Yes, issue number first, unity of title he holds, and para 44 he discusses, and then the ultimate finding is page 51, just before para 45. I find and hold that there is unity of title and possession according to so and so. Yes, and with regard to half and half share, issue number 10 at page para 49. Para 49. The issue relates to share of the plaintiff in the suit property. In this regard, the plaintiff is that after the death of Gundu Gop and Michu Gop, rest two brothers, namely Gedari Gop and Bhola Gop, each became owners of 8 annas share in the Schedule B of the plaint, whereas the case of the defendant is that the branch of Gedari Gop had 2/3 share and branch of Bhola Gop had 1/3 share in the suit property. Why it was said?
Why 2/3?
Yes, because they were relying on the earlier compromise decree, in which they had said that because Girdhari was the elder brother, therefore he had been given a larger share of Jharkhand itself.
That has been Jharkhand has been rejected by the
No, we cannot rely on that. So let us assume, Your Lordship, I have given something which is against me also. Let us assume. Now this is absolutely a question of law which arises from established facts of the case. So whether what would happen to section 18? Had it been a case where I would have said that I was entitled to a larger share, I would not have been given. So even if I have said that I was entitled to 1/3 or no, this was 2/3. So then also my entitlement to now in accordance with law would not be much. Now here the question ultimately
So
number 10.
ultimately, this was rejected.
Yes, it was.
Now we have to decide as
Open
to what
as
will
to
be
what-
the law,
absolutely,
what will
absolutely.
be as per law.
Absolutely.
Because this share on the basis of earlier whatever compromise etc.
Yes,
has
yes,
been
yes.
rejected.
It has been rejected.
So
Absolutely.
whatever be your share,
Yes.
half or three.
Whatever I am entitled to in law, I will. Then
So
you achieve.
ultimately half कर दिया.
The conclusion is at next page, last 4-5 lines. Under the above facts and circumstances, I find and hold that the plaintiff are entitled to get half share in the land described in Schedule B of the claim on partition. Whereas I have
वो
already
previous
decided.
page का last line पढ़ी है ना. I find that Girdhari Gop and Bolu Gop had half and half share in Khata number 7.
In first, yes. Then same thing as conclusion also.
That's it.
Then he says that they are entitled to half and half.
You
and
read para 50 थोड़ा सा ऊपर से. It is admitted fact that. Para
Yes, may I read it?
Yes, please.
It is admitted fact that out of 4 sons of Guddu Gop, 2 namely Bondu and Mithu Gop died issueless. According to Hindu law, their undivided interest in the coparcenary property devolved upon their coparceners, namely Girdhari Gop and Bhola Gop by survivorship, even if at the time of death of Bondu Gop and Mithu Gop, they were separate, their properties passed to their heirs by succession. In that case also, the share of Bondu Gop and Mithu Gop devolved upon their other brothers, namely Girdhari Gop and Bhola Gop, who were their heirs. As such, I find that the Girdhari Gop and Bhola Gop had half and half share in the land of Khata number 7, new Khata number so and so. I further find that the ancestor of the defendant, namely Odhan Gop, had himself admitted in the previously instituted title suit number so and so that Girdhari Gop and Bhola Gop had half share in the land of Khata number 7, which is described in Schedule B of the claim. The certified copy of the plate of title suit number 148 of 1970 has been exhibited on behalf of the plaintiff and has been marked as Exhibit 4A. I find that the admission made
Stopple
in
तो
the
नहीं लगेगा ना.
Huh?
Stopple नहीं लग सकता. Stopple नहीं लग सकता.
Therefore, I said, Your Lordship, once either my entire claim of previous partition could have been said that there was a previous partition, I was entitled to half, or whatever I am entitled to in law, then I cannot be that my previous statement is taken partially into account and the other statement is not taken.
ठीक है, इसमें तो आपको इतना ही.
Yes.
और कौन सा substantial
Yes.
of law?
Second, then ultimately he says that I am entitled to half and half. That this is with regard to Schedule B. Now what?
Exactly.
When this was raised before the appellate court,
Exactly. The learned counsel has referred to the issues framed by the learned trial court at paragraph number 25 and has submitted that the share with respect to the Schedule B and Schedule C property comes under issue number Roman 10. The admitted facts has been recorded in paragraph 27 of the trial court judgment, which is as follows. इसको quote कर देंगे, छोटा सा paragraph है. The learned counsel further submits that the unity of title and possession was decided in favor of it was held that there was unity of title and possession with respect to Schedule B property. He has further submitted that issue number 10 has been discussed from paragraph 49 to 50, and while considering issue number 10, the learned court has recorded that the defendants had claimed that they had 2/3 share, and such claim was on the basis of compromise decree but such plea was ultimately rejected, and by referring to certain pleadings in the earlier proceedings wherein it was asserted that Girdhari group and Bhola group had half and half share in the land. The same was taken into consideration, and it was ultimately decided that they had half and half share. The Learned Council has submitted that on the one hand, the claim of 2/3 share of Girdhari Go and 1/3 of Bolu Go was rejected, and on the other hand, the pleadings in the earlier partition suit was taken into consideration to give half and half share.
Yes.
The Learned Council has submitted that once the unity of title and possession was found in connection with Schedule B property, the properties ought to have devolved in accordance with Hindu Succession Act, and while giving the findings, the Learned Trial Court has completely ignored Section 18. Appellate Court.
Yes. This question was raised by us, Your Lordship, internal page 9, argument of appellant defendant. Internal page 9 of the appellant.
Yes,
Fourth point which we had argued in paragraph 12,
that's right.
that in the suit for partition, the court shall have to determine the share of the parties, and according to section 18 of the Hindu Succession Act, heirs related to an intestate by full blood shall be preferred to the heirs of by the half blood. As per Hindu Succession Act and Munda's Hindu law, two persons are related to each other by full blood when they are descended from the common ancestor by the same wife, and half blood when they are descended from common ancestor by two different wives. That Girdhari Go, being related by full blood, succeeded the share of Bundo Go and Mithu Go, and he became the owner of 3/4 share, and Bhola Go became owner of 1/4 share. So this was very clearly argued by us, but ultimately then also the appellate court discards it, and the ultimate finding of half and half is there at page 20.
What was their argument with regard to this point? Their arguments have also been recorded.
Their argument is noted at page 12,
Yes.
para 30.
Anyways, what is the finding?
Yes, the finding is that they are entitled to half and half. It starts from para 22. Now the question arises whether Girdhari Go was entitled to 3/4 share of the properties left by his
No,
father.
para 21. 25 ke just ऊपर. Therefore, I find.
Achha. That is the finding, and it starts actually from para 21 and 22.
Let's see this. Therefore, I find that.
Your Lordship is reading
Internal page 21,
21.
just above para 21.
Therefore, I find that the land is pertaining to Khata number 26 and 28, which are included in Schedule B of the plate, have not been partitioned by meets and bounds. Therefore, Girdhari Group and Bhola Group are entitled to equal half share to the land of Schedule B property. Therefore, the finding of the lower court as regards Schedule B property is concerned, it stands up.
Once there is unity of title, it becomes irrelevant who is found in possession.
Who is?
Found in possession.
Yes, absolutely.
Right?
Absolutely.
So therefore, any entry made in record of rights
Yes.
will lose its relevance
Yes,
if there is a finding of unity of title.
yes, yes. I do get you.
And therefore, this is best you can say,
Yes.
subject to what they have to say. Therefore, there is a finding that there is unity of title, there is also a finding that there has been never partition by meets and bound.
Yes.
Had there been a partition by meets and bound, then somebody might have got less, more. That is a separate phenomenon.
Yes.
But once there is a finding that there has never been a partition by meets and bound, then mere possession of one or the other portion of the property recorded in the record of rights will otherwise also lose its relevance.
Yes. As regard the properties which were Schedule B property.
Schedule only, we are only concerned
joint
with
property.
Schedule B property,
Yes.
yes, as of now. So this is one finding which has been recorded by
Yes.
the appellate court.
Yes.
And where is the further finding with regard to section 18?
With regard to
Section 18. Has it, nothing has been recorded?
with regard to share
Section
of the
18,
party.
yes.
No.
No finding has been recorded.
I did not get it.
Section 18, there is no discussion.
No. Section 18 I did not find it because it starts from page 20, para 21, and then it says in para 22, he says that now the question arises whether the Darigop was entitled to 3/4 of the properties left by his father as per doctrine of full blood and half blood, and section 4 of Hindu Succession Act whose overriding effect of section 84 of CNT Act, and the principle of estoppel or admission as mentioned in para 3 of the exhibit 5 is again the provision of the
What is
statute.
section 4 of Hindu Succession Act?
Section 4 of the Hindu Succession Act.
What is it?
It is, yes, he is right, that overriding effect. Overriding would mean that whatever Hindu law originally stood, which by the Hindu Succession Act, once it was enacted, whatever was there in the Hindu Succession Act, the provisions which were contrary to Hindu Succession
That will
Act,
get overridden.
they are overridden, not
Provided it is contrary.
Absolutely.
So there are two kinds of, when there is a law codified, it is suppose there is customary law codified, then whatever is existing may be codified and something new may be introduced.
Yes.
If there is anything contrary in the customary law, then similarly in this,
Absolutely,
in the
and-
case of codification also,
Yes, yes. And if there is nothing to cover, then obviously those portions would still stand.
yes. Okay. This 22, then
Para 23 here, sir. The date, month and year of death of Gudru Gop and Mitru Gop as well as wives of Gudru Gop has not been stated by any witness. Neither any document or substantive oral evidence has been brought. I am in agreement with the submission of the learned counsel for the respondent that share of the co-partner in a co-partnerary property increases or decreases as per variation in the family members. The counsel of the appellant defendant has stated that it is mentioned in the pleading as well as in the evidence that Gudru Gop in his lifetime divided his property in 3 equal shares, and one Jharkhand's share was allotted to Girdhari Gop and 2/3 share Girdhari Gop and his brothers born from first wife, and 1/3 to Prola Gop. There is no documentary evidence to prove para 13 of the written statement. Although this fact has been stated by DW1 in his evidence in chief, DW2, Mansa Gop is an elderly man of the village, village so and so, and he has stated that only 2 persons were allotted Jharkhands in his village, namely Biglara and Namrata. He did not take the name of Girdhari Gop, and the second thing to be considered that if Gudru Gop divided the property in 3 equal shares, and 1 share was given to Girdhari Gop as Jharkhands, and other 2/3 Girdhari Gop and his brother, and 1/3 to. I don't know why this calculation is being mentioned, because my claim to 2/3 was being denied. So when I am saying that relying on section 18, then the question of section 18 only ought to have been discussed. not with regard to what was my claim with regard to Jharkhand's share.
Technically, there is no discussion about section 18. He
No,
mentions
it
in
is
paragraph
not.
22.
It is not there.
He mentions in paragraph 22, but there is no discussion of the impact of section 18.
Yes, he does not. He only one line, Your Lordship. He says that I am in agreement with so and so, and that it is a co-personary property. But here he fails to note that the plaintiff's case is very clearly that it was a property of Budrugo. It was not an ancestral property. It was a property of Budrugo, and it obviously his property would devolve on his 4 sons equally. So once there was a devolution of 1/4 share on 2 issueless persons, then their share would go.
While referring to the judgment passed by the learned first appellate court, the learned counsel has referred to paragraph 11, which records that the whole argument of both the parties hinges upon findings with respect to issue number 8, 9 and 10. He submits that the arguments of the defendants have been recorded in paragraph 12, wherein the argument with respect to section 8 of the Hindu Succession Act has been recorded in paragraph 12 within bracket 4, within bracket 5 and within bracket 6 has been recorded as follows. इसको quote कर देंगे 4, 5, 6 को. The learned counsel has further submitted that the arguments of the plaintiff has also been recorded in paragraph 13 of the appellate court judgment, but no specific argument with regard to section 18 has been mentioned. The learned counsel has further referred to paragraph 22 of the appellate court judgment, by which the learned first appellate court has mentioned about section mentioned about the claim with regard to applicability, with regard to share of full brothers slash full blood slash half blood. But in the findings, but he submits that in the findings from paragraph 23 to 28, there is no discussion about the applicability of section 18 of the Hindu Succession Act. Paragraph 22, paragraph 21 to 24 is quoted as under. The learned counsel has submitted that once the genealogy is not in dispute, the nature of relationship is also not in dispute. The date, month or year of death of Yudugo, Bodugo, Mitugo, as well as the wives of Yudugo has not been brought on record. The applicability of section 18 of the Hindu Succession Act, the property ought to have devolved in the ratio of 3/4 is to 1/4. हो गया?
Yes.
कौन सा जजमेंट आप बोल रहे हैं अभी?
this is Bombay High Court.
अब बोले थे कोलकाता है।
कोलकाता हमको
देखिए बॉम्बे को रिलाई करने में थोड़ा सा इसलिए दिक्कत है क्योंकि वहाँ पे थोड़ा लॉ अलग है।
अच्छा ठीक है, but I'm just referring to one line that after quoting Hindu law, the Honorable Court says that it is more or less same reproduction of the, in para 13 it has said. The effect of all these provisions is that the distinction between male and female heirs in the matter of succession have been removed and male and female heirs have been treated equally in the manner of succession of so and so. The provisions of section 13 of Hindu Succession Act will have now to be considered in the light of all the object of the said act was enacted. Now, on a plain reading of the provisions of section 18 of Hindu Succession Act, it appears to be clear that it is nothing but a substantial reproduction of the prevalent rule of Hindu law, under which the relations of the whole blood were preferred to those of the half blood if their degree of relationship to the deceased was the same. Section 18 provides for a preference of one category of heirs to other under section so and so. So therefore, Your Lordship, absolutely same. Para 13.
The learned counsel has relied upon full bench judgment of Honorable Court, Bombay High Court, reported in 1983 SEC Online Bombay, and has submitted and has referred to paragraph 13 thereof to submit that it has been clearly held that a plain reading of provision of section 18 of Hindu Succession Act appears to be clear that it is nothing but a substantial reproduction of the prevalent rule of Hindu law, under which relations of the whole blood were preferred to those of half blood if their degree of relationship to the deceased was the same. The learned counsel has submitted that the aforesaid finding of Honorable Bombay High Court is find support from the aforesaid discussions made in Mulla Hindu law. है ना?
Yes.
ये
That is all.
मंगाए हैं 66.
वो कैलकाटा होगा इतना सारा I have taken out of print out that all now
कोई बात नहीं.
There's one 1982 Division Bench of Calcutta High Court, in which the question of whether the half-blood sister could have been joined along with the full blood brother, the question was decided. This is the 2 pages. Although this was a question whether the half blood also can be substituted along with the full blood, whether they inherit. So while relying on section 18, it was said that no, they are
That to be excluded.
yes, because the argument here was it only says that with regard to half blood brother, not half blood sister. So this was the argument. It was said that once the relationship is same, it would cover all. That means brother, sister, whatever it is.
Now, after the coming into force of Hindu Succession Act, the children of same father from different mother will inherit the properties.
No. Therefore, section 18 is also there.
That's right.
Yes.
But section 18 is also there.
Yes. If he has 2 wives and the children are there,
Yes. They
both,
will inherit.
all would inherit simultaneously.
Simultaneously.
Yes.
But if the children are from different father and same mother, then they will not inherit.
Here the problem is, Your Lordship, it is not a question whether what would happen to father's father. Father has already died, his property has already devolved on his 4 sons. So after this has already happened, so each of the 4 sons has 1/4. This is absolutely not in dispute. So what would happen to the 1/4 share of the 2 persons
Who have expired.
who expired after the obviously inheriting the property? They had already inherited. So
Had the inheritance not taken place,
yes.
then it would evolve.
Then the matter would have been different. Here, the plaintiff himself in his plaint very clearly says, I'll read out that part, portion. Your Lordship may see the statement. It is quoted in the judgment itself, both the trial court and the appellate court. Whichever Your Lordship takes up.
Just a minute.
In appellate court judgment, para 2, he says plaintiff's case. Only one paragraph out. Only one paragraph.
Yes.
One paragraph of plaintiff's case. In appellate court judgment also, if your chip sees
I will see appellate court's judgment.
appellate court's judgment, second page, para 2. The case of the plaintiff is that Gudru Gop was common ancestor of the parties who had acquired. It was not ancestral property. They say that Gudru Gop was the common ancestor of the properties who had acquired some land in village so and so, so and so.
Appellate court judgment of para 2 को कुछ और
Oh, sorry. I was reading the
ट्रायल कोर्ट से भी देखो.
trial court का para 2 पढ़ रहे थे, but same thing has been
एक ही
mentioned
बात
in
है, हाँ. The case of the plaintiff is that Gudru Gop was common ancestor
of the parties who had acquired some land in village Bujur, Zamira under so and so, which were recorded in his name in the record of right of the last cadastral survey and settlement under Khata number 7. Said Gudru Gop had 2 wives. From the first wife he had 3 sons, namely Girdhari Gop, Hundu Gop and Mitu Gop. Out of them, 2 sons, namely Hundu Gop and Mitu Gop, died issueless and their branches were extinguished, and their share devolved upon Girdhari Gop, who became the shareholder to the extent of it. So they themselves say that their share devolved on Girdhari Gop. And then they say that we were entitled to only 8 annas. From the wedlock of second wife, Gudru Gop had only 1 son, Gola Gop, who became the co-sharer of 8 annas share. Gola Gop died, leaving behind 4 sons.
From the wedlock of second wife, Gudru Gop had 1 son, namely Gola Gop, who became co-sharer of 8 annas. This is
Yes.
what they are saying.
Yes.
So it is an admitted position that he was the co-sharer of the property. Both of them, at one point of time.
Yes. Co-sharer would only mean entitlement, not exact share, but
No, but co-sharer.
I am also entitled to unity of title is there between us. That is. So only to conclude, your Lordship, my submission is absolutely clear that Gudru Gop died leaving behind 4 sons. His interest, because he was the person who had acquired the properties, all the 4 sons equally had 1/4 son. There's
The
absolutely.
council has submitted that Gudru Gop died leaving behind his 4 sons, and therefore, upon his death, the property equally devolved upon each one of them. And upon death of 2 of them who were full brothers of Girdhari Gop,
Girdhari.
their share would have gone to the share of Girdhari Gop, and the 4th son through second wife would not acquire any property on account, any further property on account of
Death
death.
of. Yes.
और भी कोई क्वेश्चन आप लॉ बनाना है इसमें?
नहीं.
बताइए.
And then the second one I'll argue.
No, later. पहले इसको.
After this one.
First thing which I would like to say.
First thing, he has said many things which are undisputed according to him.
According to him,
Genealogy is disputed.
not so far as the genealogy is concerned, it is not disputed that this property is of Gudru Gop, who was having 2 wives. And so far as this respondent your lordship is concerned, they claim the property through the second wife, and he claims through the first wife. That is not allowed.
Can I take your lordship?
But your lordship, in a co-partitionary property, it is admittedly a joint family co-partitionary property. When a shareholder dies, then my lord, it devolves on other. This is the law. So no question of inheritance. What my friend was arguing. If there were only two surviving co-partners or co-sharers, then one was my lord, the Girdhari ko, and my lord, another was Bhola ko, and accordingly, my lord, the half of the property actually devolved to each of them.
Just a moment. Is it a fact that this, the common ancestor died leaving behind 4 sons? Or he
That is
died
also-
leaving...
That is not it.
That is your case?
That is not has come. But
No.
the
That is your case.
But that is my case is that they died issueless.
No, they died issueless.
Yes.
But he died leaving behind 4 sons. Is it a fact or it is not?
My lord, may kindly see what is in the plan. Let us see, my lord, what is in the plan. May I be permitted to read part of the plan? Record has come.
Like,
It is admitted.
has it been wrongly recorded in the improved judgment?
No, I am reading part 3. Let me my lord, read it. He had 4 sons, that I am not saying, but they died issueless. So if a co-partner dies, the property gets to devolves to another co-partner. This is what is the law. What Hindu law?
You see, your case is that 2 sons they died issueless,
Yes. Yes.
and their branch extinguished,
Yes.
and their share devolved upon Girdhariko.
To the extent of 8 sons.
So therefore,
Yes.
they had a share, but they died issueless, and therefore their share devolved. It is not your case that they did not acquire any share itself.
Your lordship may kindly appreciate.
It is one thing to say
But
that they died during the lifetime of their father, and nothing as such devolved upon them. And since they died, and thereafter their father died, it devolved only upon 2.
this will not make a difference. As because. So far as the son of a second wife is concerned, or a son of a first wife is concerned, in law there is no material difference. When there are judgments to that effect also. Even my lord, the illegitimate sons arising out of a second marriage, they are on equal footing, my lord, on the original sons. Even in the ancestral property, certain recent judgments of Supreme Court has come to that. So far as my lord, the son from the first wife or the son from the second wife, this would have no material bearing, as because both were co-partners.
So you want to say that in a case where there are 2 wives
My
and children arising out of their wedlock,
My-
different wedlock, Section 18 will have no applicability.
what I want to contend, what I want to contend, that my lord, in a case when there are whether they are a co-sharer or co-partners or not, that is the prime consideration to be considered. If he is not a co-partner, or if he cannot be deemed to be even a co-sharer, then the matter would be other. But here in this case, it is an admitted fact there was no partition by means and bounds. Once there is no partition by means and bounds, then my lord, what is then there is a unity of title and possession. Now only question comes to suit. so far as the pleading is concerned, our pleading, Your Lordship, is that followed to the half and half to the 8 anna extent to the extent of 8 anna.
खाली 8 आना तक मत पहुंचिए, उसके पहले का कहानी भी पढ़िए।
हम पढ़ लें, हम तो पारा पूरा पढ़, पारा 2 से ही पढ़ते हैं। Guru Gop acquired some land in village Bujugaria, Paragana, Chagangala, Thana, Ramgarh, at present Padratu, Thana, Surgeon, during the last cadastral survey and settlement operation, were recorded in the name of the Khata 7 of the Bujuga Gamira within the jurisdiction of this world. Guru Gop had 2 wives. From first wife, he had 3 sons, namely Girdhari, Gop, Bodhu, Gop, and Viju. But later 2 sons died issueless, and the branch extinguished, and their share devolved upon the Girdhari Gop, who became the shareholder to the extent of 8 anna from second wife. Guru Gop had 1 son named Bhola Gop, who became the co-sharer of the 8 anna share. He died leaving behind both sons, namely Vasudev Gop, who died issueless, Rima alias Rama Gop, Ladva alias Gop, and Vinu Gop alias Vindeswar Gop, who are plaintiffs in this suit. Similarly, Girdhari Gop died leaving behind 4 sons, Bodhan Gop, Soma Gop, Dimar Gop, Govardhan Gop, and 2 daughters, namely Sajjan Sar.
You see, the very fact that you say that their share devolved upon Girdhari Gop.
Share means share of
Co-pastoral
original share of
co-pastoral property.
Co-pastoral. And he devolved to the extent half and half. If had they been alike, then the matter could have been other. He is also a co-pastoral. He is the son of Gurdi Gop. Property is not of wife. Property is of Gurdi Gop. And he.
You just tell us, under normal superpartition, when there is a common ancestor, and there are 2 branches, one branch has 4 sons, other has maybe 5 sons.
One thing I would like to say.
Just a moment. And out of those 4 sons, 3 died. Only 1 survives. Then the property will be half and half. Or the half to 1 son and half to 5 sons together. Or it will be 1/6 of the share.
It will be, everybody will be same.
It will be divided as 1/6 of the share.
Yes, that what is the, as per the Hindu succession. If the property is of a Hindu Indian state, then it will be governed by section 9, section 8, section 9, and there are stages. If the class 1 is available, then it will go to class 1.
No, I want to know. You see, my question is very clear. There is an ancestral property. There is a common ancestor. Self-acquired property. He has 2 sons. One has 4 sons and other has 5 sons. 9 बच्चे हो गए, 2 बेटे के. Out of the 1 branch, 3 died. Only 1 survives. 4 बच्चों में से एक भाई का एक ही बेटा रह गया, और दूसरे भाई के 5 बेटे हैं. तो जब पार्टीशन होगा तो 1/6 शेयर जाएगा जिसका एक बच्चा रह गया, या उसके पास हाफ शेयर जाएगा.
This will depend upon that initially there will be notional partition.
Notional partition होगा ना?
What minority?
Yes, there will be a notional partition between 2 brothers.
But if it is a proportional property, then the position.
It is a co-pastoral.
Position would be different. Only the living co-partners will share equally. What is the recent judgment of that judgment of Rakesh Sharma judgment? My lord has been in very detailed way those co-pastoral concepts have been explained. Rakesh Sharma versus Vinita Sharma. Now, my lord, at this stage, living co-partners living co-partners. The word is living co-partners.
Living co-partner would be there, but
They-
still
they
the
will-
notional partition has to be there.
Among the
We can't ignore the
to
notional
ascertain
partition.
this year. To ascertain this year.
Certain to ascertain the share. तो भाई एक भाई का एक ही बच्चा रह गया, दूसरा भाई के 10 बच्चे हैं, राइट?
हाँ नहीं ठीक है.
तो क्या 1/9 शेयर तो नहीं जाएगा ना एक भाई के इकलौते बच्चे को?
हाँ.
It will be divided half to one that child of that.
That will depend upon.
जैसा हम लोग कॉमन नॉलेज से बता रहे हैं, आप हमको लॉ दिखाइए, लेकिन कॉमन नॉलेज हमारा यही कहता
I'm
है.
saying so. What my lord is saying, it is with respect to a property which has been acquired by self-acquired property.
सेल्फ एक्वायर्ड प्रॉपर्टी है, लेकिन मरने के बाद तो एंसेस्ट्रली हो गया ना.
No, that depends.
भाई मरने के बाद किसी भी if I acquire property and if I die, it becomes ancestral property for the remaining years. और कैसे ancestral? कहीं लिखा है कि 4 पुश्त होने पर ancestral property होगा?
That what I'm saying. तो पार्टनर का मतलब वही होता है, 4 पुरुष.
देखिए, co-partner, एक सेकेंड. Those persons are not co-partner to the self-acquired property of the common
So
ancestor.
प्रॉपर्टी में को-पार्टनर.
Co-partner नहीं होंगे, लेकिन उनके मरने के बाद
को-पार्टनरी डेवलप कर सकता है.
वही डेवलप करेगा. Then under such circumstances notional partition तो होगा ना.
नहीं, नोशनल पार्टीशन.
नहीं तो ये तो क्योस हो जाएगा. आप बताइए सोसाइटी में क्योस होगा कि नहीं जाएगा? जो हम लोग रोज देखते हैं कैसा पार्टीशन होता है?
नोशनल पार्टीशन टू असर्टेन दिस शेयर करना पड़ेगा.
करना
I
पड़ेगा
agree
ना.
to that.
तो यही किया, इसमें भी यही कर.
इस पर्टिकुलर केस वो दोनों जैसे ही कोई को-पार्टनर का डेथ होता है या कोई शेयरर का डेथ होता है, उसका शेयर डिवॉल्व करेगा. अब अगर उसके कोई वारिसान हो या कोई अगर विडो हो, उसके हिसाब से उसके थ्रू होगा. तो पुराने एक्ट के हिसाब से
It will devolve through survivorship, right?
Yes, yes.
When it will devolve through survivorship,
इनहेरिटेंस का कॉन्सेप्ट नहीं होगा.
then under such circumstances section 8 is not required to be seen.
Section 8 is required to be seen with respect to co-partnering property. अगर
हाँ
है.
लिखा है co-partnering property.
अब आपके समय में तो हो ही गया. नया वाला तो आ गया. तो नया वाला पे तो इसको
इस तरह से डिवीजन नहीं होता है.
नहीं, प्रॉपर्टी में जैसे हम कहना ये चाह रहे हैं.
ऐसा लॉ मत
नहीं,
करवाइए
ऐसा लॉ नहीं करा.
कि आपको मुश्किल हो जाए.
नहीं, हम ऐसा लॉ कभी नहीं करेंगे. हम इसमें ये कहना चाहते हैं कि को-पार्टनरी प्रॉपर्टी अगर है और अगर ये सारे को-पार्टनर थे तो एक को-पार्टनर का डेथ हो गया तो उसका शेयर डिवॉल्व करेगा ऑन द रिमेनिंग. तो अगर उसको को-पार्टनर था ही नहीं या ये इसका कोई शेयर ही नहीं था तो इसके केस पे इसका केस का डिवॉल्व करने का इसमें कोई नहीं होगा, जो कि इन लोग का स्टैंड.
नहीं, उसका तो शेयर था ही.
नहीं, ये कह रहे हैं कि नहीं था शुरू में.
अरे वो क्या कह रहे हैं, आप क्या कह रहे हैं?
नहीं,
उसकी
हमारा
चिंता
तो कहना
कर
है
रहे
हाफ एंड
हैं.
हाफ
आप प्लेंटिफ हैं, आपकी बात हम सुन रहे हैं.
इनका तो शुरू से कहना था कि
आपका
मेरा
कहना
कुछ नहीं.
आपका कहना ये है कि आफ्टर द डेथ ऑफ 2 brothers
हाँ.
their property devolved on the
Both of
remaining 2 brothers.
both of them
आपका ये कहना है?
half and
ठीक है, उनका कहना ये है कि आफ्टर द डेथ ऑफ 2 brothers it will devolve on full brothers and not on half brothers.
मेरा इसमें
इतना ही तो एक लाइन का तो यही केस है
इसमें तो हमारा ये कहना
जो हम लोग इतना रेसिस्ट
हमारा इसमें ये कहना है कि ये कह रहे हैं हाफ ब्रदर, ये अपने ब्रदर का शेयर खुद चाह रहे हैं. अब जब लेकिन सवाल है कि ये प्रॉपर्टी इनके ब्रदर का इनका हो सकता है, लेकिन प्रॉपर्टी तो फादर का है ना. और फादर का
मर गए.
प्रॉपर्टी
कौन आदमी प्रॉपर्टी लेके मरता है?
वही नहीं मरता है.
छोड़ के मरता है ना. छोड़ के मरे.
नहीं, तो इसीलिए तो हम भी कह रहे हैं कि ये जो ये अपने भाई का प्रॉपर्टी कह रहे हैं कि और ये फर्स्ट वाइफ से चुकी हैं, इसके चलते ये लॉ इस पॉइंट में एप्लीकेबल नहीं. और इसका कारण क्या है कि अपीलेट कोर्ट ने ठीक कहा कि इसको पार्टनरी प्रॉपर्टी का शेयर ऊपर नीचे होते हैं. दैट पारा माय फ्रेंड रेड इट, आई एम रीडिंग इट फॉर. अच्छा, दूसरी बात है कि जहाँ तक कि प्रेफरेंस का बात है तो दोनों तो एक फर्स्ट वाइफ से हैं, सेकंड वाइफ से. हमारे लिए ये भी तो ये है क्या उसको बोल रहे हैं जो व्हाट यू
फर्स्ट वाइफ, सेकंड चाइल्ड इज एन
नहीं हम दूसरी चीज
illegitimate child.
हम फुल ब्लड एंड हाफ ब्लड जो कह रहे हैं.
Second child is an illegitimate child.
फुल ब्लड
But by operation of law they are entitled to share.
हम दूसरी बात कर रहे थे फुल ब्लड का जहाँ तक बात है तो फुल ब्लड ये कह रहे हैं कि हम फुल ब्लड है हमको ये हाफ ब्लड बता हम दोनों का रेस्पेक्ट में ये हाफ ब्लड हमको भी कर हमारे लिए भी तो हाफ ही ब्लड है
हाँ तो आपके लिए भी हाफ
हाफ ब्लड है
अगर आप बनिएगा
एक
एक सेकंड in case you die then under such circumstances you don't have any sibling you have any sibling
हाँ
अच्छा तो फिर in case you die the entire property will go to your full sibling and it will not get divided to those who are born out of another wife of your father.
That what he is saying.
This is
That
what
he is doing.
that sounds.
But I very humbly say, that in this particular case, at the relevant point of time, both the brothers were there, and there was no partition by bits and all. Appellate court has rightly said that it is half and half. Both the courts have concurrently said that it is half and half.
अच्छा वो छोड़ दीजिए आप
But
मान लीजिए दो बच्चे हैं एक का एक बेटा है और एक का 3 बेटा है एक ब्रांच में फर्दर एक बेटा हो जाता है फर्दर नहीं You see, when we will decide टू वाइफ्स का हम लोग भाई का बात करें पहले ना वाइफ्स का बात हम लोग बाद में करेंगे ठीक है देन अंडर सच अगर मान लीजिए एक ब्रांच में डाउन द लाइन आल्सो एक ही बेटा है दूसरा ब्रांच में देयर आर नंबर ऑफ चिल्ड्रन 10-12 बच्चे तो जब पार्टीशन होगा तो 10-12 बच्चों को जोड़ के एक के साथ होगा
नहीं उसमें कोपार्टनर वाला चैप्टर से हम मजदूर को दिखाएंगे अगर आप कोपार्टनर नहीं बने हैं जैसे आपको उस लाइन में नहीं आएगा तो नहीं मिलेगा उस वहां तक ही आएगा उसके बाद नहीं आएगा तो आपका नहीं होगा डिपेंड करता है कि नेचर ऑफ प्रॉपर्टी क्या है अगर सेल्फ एक्वायर्ड प्रॉपर्टी और इट इज गवर्न्ड बाय हिंदू सक्सेशन एक्ट इफ द पर्सन हैज डाइड इन दिस देन इट विल बी गवर्न्ड एज पर द सेक्शन 8 उसमें आपका
अच्छा कौन सा पैराग्राफ
हाँ,
देख रहे हैं
लेकिन
इतना भी
वो
क्लैरिटी
उसका
नहीं है
application
जजमेंट
इसमें
में
नहीं-
इसीलिए
नहीं
सब्सटेंशियल क्वेश्चन बताइए कौन सा पैराग्राफ आप बोल रहे हैं एपेलेट कोर्ट का कोई जजमेंट बोल रहे हैं
पढ़ा खुद पढ़े तो पढ़
Does the illegitimate child acquire the status of co-partner?
अब तो हमको लगता है निश्चित रूप से
निश्चित अब लगता है पहले नहीं लगता
पहले नहीं था
कुछ
पहले
तो
सुप्रीम
दिखाई
कोर्ट का कुछ जजमेंट खिलाफ था अब सुप्रीम कोर्ट का जजमेंट
The
था
ancestral property
ये
does not
लैंडमार्क
give-
जजमेंट
he does not does he get any right over the ancestral property
यस सुप्रीम कोर्ट का जजमेंट को हम दिखाएंगे इसमें आया रिसेंट जजमेंट से
just a moment he gets just a moment जहाँ तक हमको ध्यान पड़ रहा है सुप्रीम कोर्ट का जजमेंट में अगर मान लीजिए कोई एंसेस्ट्रल प्रॉपर्टी है देन नोशनल पार्टीशन में वो उस आदमी का प्रॉपर्टी माना जाएगा एंड देन इफ ही हैज एन इलेजिटिमेट चाइल्ड देन इट विल गो राइट बट डज ही एक्वायर द स्टेटस ऑफ ए को-पार्टनर ये दोनों अलग बात है
दोनों अलग बात
बहुत फर्क है दोनों
एग्री टू दैट लेकिन ये अगर हम उसमें उस पॉइंट पे कर रहे हैं
क्योंकि आप co-partner की बात कर रहे हैं इसलिए आप इसका कहा है।
simply somebody is a son arising out of a wedlock which is not legitimate wife may not have a right but the
Wife को
children
तो कोई
will have a
right
right he is as
Children will have a right,
right
but the point is whether they will acquire the status of a co-partner of the family.
that will depend at the original son will having a status or not
Original son means
arising out of a valid wedlock
भाई वैलिड शादी तो एक है
हाँ
लेकिन एक जो इनवैलिड शादी है सेकंड मैरिज है which is not recognized under law
हाँ
right
हाँ
if their children also acquire do they also acquire the status of co-partner in the family
they will acquire the status of as per the law
they may get right to property but do they acquire the status of a co-partner in the family बहुत डाउटफुल है आपका ये proposition.
ancestral property में right उनको
राइट मिलना अलग बात है मिस्टर शर्मा बट getting the status of a
अगर
co-partner,
ancestral property में आप हमको right दे रहे हैं,
तो आप ऑटोमेटिक co-partner हो गए.
नहीं को automatic नहीं होंगे, but
Yeah.
I will have a right in the ancestral property also.
You will have a right to the ancestral property depending upon the share कैसे devolve
Exactly.
करेगा क्या
Exactly.
करेगा. But you will not acquire the status of a co-partner.
That I would like to examine. That I would like to examine. I will won't say today, but that is so far as
ऐसे भी समाचार हो
नहीं
जाते हैं.
आप ऐसे इसमें हुजूर सागिर अहमद साहब का जजमेंट 1996
आप दिखाइए, आप देखिए ऐसे जजमेंट बोलिएगा तो हमको
हमने
याद
हम
है.
दिखा हम वो जजमेंट के बाद में ही उस जजमेंट के बाद में
आप कौन-कौन से जजमेंट एक रिलाई कर रहे हैं? कौन सा एक बार माफ क्या?
एक सागिर अहमद साहब का जजमेंट है 1996 का सुप्रीम कोर्ट का जजमेंट है. उसी जजमेंट के बाद इलीजिटिमेट चिल्ड्रंस को राइट दिया गया.
नहीं, राइट देना एक बात है, लेकिन परिवार में स्टेटस देना दूसरी बात है. यू सी इन जनरल
एक बार
फैमिली में
एक बार right
जस्ट
दिया.
अ मोमेंट, एक सेकंड. फैमिली में अगर मान लीजिए डेथ हो जाता है father का, तो लास्ट राइट्स परफॉर्म करने के लिए इलेजिटिमेट चाइल्ड को नहीं बुलाया जाता. Who has got it? That is also a right of Hindu.
that is
ठीक है, नहीं बुलाया जाएगा ना उसको. इलेजिटिमेट चाइल्ड अगर वो बड़ा भी है तो भी वो लास्ट राइट परफॉर्म नहीं करता है.
सुप्रीम कोर्ट के ऑर्डर से जो अपना हो गई
अब तो क्या है, लड़की लोग भी करती है, लेकिन ऐसा तो सिस्टम नहीं था
लीगल
पहले.
राइट.
ठीक है,
असल चीज तो राइट ही ना है.
नहीं राइट.
कस्टम्स एक कस्टम्स का अगर थ्रू आउट अगर उसका फॉलो हुआ
देखिए, प्रॉपर्टी में राइट दे देना अलग बात,
तो वो मान दैट है.
लेकिन फैमिली में एक स्टेटस दे देना अलग बात.
सुप्रीम कोर्ट के ऑर्डर से तो मिल नहीं रहा.
सुप्रीम कोर्ट के ऑर्डर से स्टेटस आप दिला रहे हो. ठीक है,
सुप्रीम कोर्ट का जब सुप्रीम कोर्ट ने कह दिया तो उससे बड़ा कोर्ट कौन?
आपका कोर्ट है ना, आप बहस कर रहे हैं.
सुप्रीम कोर्ट ने जब कह दिया तो
कौन कौन सा जजमेंट आप साइटेशन आप हमको दे दीजिए भाई. ऐसे नहीं होगा, ये कहानी ऐसे नहीं खत्म. Do they acquire the status of co-partner by any chance?
No, absolutely.
Yeah, this is important because his argument is that upon death of one of the co-partner, the property does not devolve by survivorship. The property devolves by survivorship and it does not go by inheritance.
Yes.
No, here.
This is what he's saying.
I'll answer. Very simple, it is not a question of going down the line. Here the question is whether the four brothers, they would be co-partner to each other on the father's property. It cannot be. Because directly father dies and they are inherited. It was father's own acquired property, his own estate. And had it been an ancestral property, then even assuming his argument, then he could have said that he was a co-partner. Although a second
Ancestral
wife.
property maybe I don't
नहीं,
think that
नहीं,
he will acquire the
ancestral
status
नहीं
of
है,
a
second.
co-partner.
ये-
He may be acquiring equal rights,
Yes.
right to property,
Right to father's property, not to ancestral property. He
to
may
the
be-
extent the
Yes,
father gets
absolutely.
it.
As son of so and so, he may have 1/4 share.
Because once the property devolves upon the father, he has exclusive right to deal with that property, and the difference between he has got exclusive right to deal with that property, unless some other children are born.
But in this particular case, there were only two surviving, and accordingly, half and half.
ठीक है भाई, थोड़ा सा कब बहस करेंगे ये बताइए.
So अगले हफ्ते
अगले हफ्ते ही रखेंगे, लेकिन
इसमें और
कंटिन्यूटी थोड़ा सा अब तो समझ आ गया ना भाई हम लोग को क्या करना है.
absolutely,
थोड़ा
absolutely.
रिटन सबमिशंस बनाइए और थोड़ा सा जजमेंट्स
देखिए.
जो भी आप प्लेस करना चाहते हैं
इसमें
करिए.
तो ये पॉइंट फ्रेम किए हैं या जो आगे कर रहे हैं सेक्शन 18
देखिए, आपका सेक्शन 18 तो एपेलेट को टच ही नहीं किया वर्चुअली.
वो तो एक हुजूर का जजमेंट
टच वो हम ही लोग नहीं सक रहे हैं अभी, तो एपेलेट कोर्ट नहीं सक रहा होगा.
आएगा इसमें लेकिन सेक्शन 18 इसमें एप्लीकेबल नहीं.
इतना जितना दिए है ना उतना टाइप करिए. ठीक है, द आर्गुमेंट्स हैज रिमेन इनकंक्लूसिव. मंडे को क्या है भाई, मंडे को लोग बहुत मिसलीनियस चीजें रखते हैं.
Thursday को
Any date
For
convenient.
further
I'm not
arguments
saying
on
it.
next Thursday. Treated as partner. The learned counsel for the parties are also directed to prepare short synopsis of arguments and also supply supporting judgments, if any, along with the written submissions, at least 2 days prior to the next date. ये काम आप प्लीज करें, क्योंकि आप जो हमको देंगे उसी के बेसिस पे हम काम करेंगे.
Yes, yes. We'll go.
अभी तक ये इशू डिसाइड नहीं हुआ सुप्रीम कोर्ट से, हमको तो लगता हो ही गया होगा.
नहीं, ancestral वाला तो हो गया. I'm just trying to find it out. In ancestral property, the illegitimate child would not have a right. Only his own father's property. Then he would have a share as a son of suppose.
तो बोले विनीता शर्मा
अभी
में ये
बोल
भी
रहे हैं
डिसाइड हो
हम.
गया. विनीता शर्मा इज रिलेटिंग टू विमेन्स राइट टू प्रॉपर्टी.
but proportionally matters.
अरे
Very
co-parceler,
interesting.
an illegitimate child would become a co-parceler of the family.
No,
And
no,
और
here in
कुछ
this
भी
case
है.
they are not illegitimate. That is not a question.
that is
But
what
I am seeking parity. I was only saying that he is a valid son and he is also a
वैलिड
valid
जब
son.
जन्म हो गया तो वैलिड ही है.
अच्छा तो उसके बाद ये भी आते हैं हम भी आते
जन्म के बाद ही वैलिड.
हैं। हमारे लिए ये भी हाफ ब्लड है, हम इनके लिए भी
So
हाफ ब्लड.
therefore, this was the reason Hindu law में this was the
Why perfect?
नहीं तो ये
closer.
फुल ब्लड एंड हाफ ब्लड का कॉन्सेप्ट क्यों? और आप हमको ये बता दीजिए कि इस पर्टिकुलर सर्कमस्टांसेस में सेक्शन 18 इज एक्सक्लूडेड. फिर सेक्शन 18 का एक्सक्लूजन हमको होल्ड करना पड़ेगा इस सर्कमस्टांसेस में. तो एक्सक्लूड कराने के लिए आपको कुछ बताना पड़ेगा ना. ऐसे हम एप्लीकेबिलिटी ऑफ लॉ नहीं एक्सक्लूड कर सकते हैं अनलेस इट इज फ्लोइंग फ्रॉम द सेक्शन और इट इज फ्लोइंग फ्रॉम सम
इसमें ये
जजमेंट.
एक material consideration कि who was the persons who had the right at the point. जो ये कह रहे हैं कि इनके दो ब्रदर, इनका कुछ भी इनका प्रिंट, इनका जो रिटर्न स्टेटमेंट में कोई ना डेथ का कोई डेट है ना कुछ है, कुछ भी नहीं है इनका.
आपका नहीं ड्यूटी
नहीं, हम तो कह रहे हैं हमारा है, हम तो हाफ एंड हाफ कह रहे हैं.
आपका
ये
आपका
इनका
ड्यूटी
self
नहीं
claim
था
कर
कौन
रहे हैं.
कब मरा और कौन कब नहीं मरा बताने का.
ये न क्लेम कर रहे हैं कि इनका भाई का शेयर इन्हीं को जाना चाहिए. तो इनको भी तो
और
प्रिडिक्ट करना चाहिए.
आपके पिताजी का कब डेथ हुआ ये आप नहीं बताइएगा प्लेनली.
ना, वो तो
वही ना, बहुत सोच समझ के नहीं बताया गया. हम लोग को सब पता है. ये थोड़ी है आप लिटिगेंट को कम मत समझिए. दे आर स्मार्टर देन यू.
2023 का जजमेंट आया है.
अब बताइए क्या जजमेंट आया है.
2023 क्या है?
2023 INSC 78
पार्टी नाम
रेवन्ना सिद्धप्पा वर्सेस
लिख
मल्लिका.
के दीजिए. ये तो पढ़ा है जजमेंट. क्या बोला है इसमें. राइट की बात नहीं है, वो पास्टरी स्टेटस की
टोटली
राइट की बात.
वो बात करेंगे
वो पास्टरी स्टेटस की बात.
करेंगे. नहीं ऐसा कह रहे थे कि नहीं इसमें नहीं दिया गया.
ना हम देख लेंगे. स्टिल डाउट उसको जब तक डीप में नहीं पढ़ेंगे.
जब तक वो पास्टरी स्टेटस नहीं होगा तब तक सर्वाइवरशिप से नहीं जाएगा. करेक्ट.
नहीं, तो इस पर्टिकुलर केस में वैसा है. इसमें तो ये भी नहीं कह रहे हैं कि हम एलिजिबल चाहिए. इनका तो ये भी कह रहे हैं कि सेकंड वाइफ हो
क्या है नहीं सेकंड वाइफ बोल रहे.
डिपेंड करता है क्योंकि फर्स्ट वाइफ के डेथ के बाद अगर मैरिज करते हैं तो इट इज अ वैलिड मैरिज. अगर सर्वाइविंग स्पाउस के रहते अगर सेकंड वाइफ कर रहे हैं तब ना उस पर एलिजिबिलिटी से कॉन्सेप्ट आएगा. वो तो इनका कोई प्रीडिंग भी नहीं है, कुछ कहना भी नहीं है. बोथ ऑफ अस आर वैलिड सर. ये भी वैलिड है और ये इनके लिए हम भी हाफ ब्लड है, ये भी हमारे
So
लिए.
Rahul, you have to take care of this.
यस यस.
सेकंड मैरिज मरने के बाद हुआ, कौन कब मरा,
नहीं वो हम
वो उसका क्लैरिटी बहुत
मान
जरूरी है.
रहे हम फिर भी just repeat last line. So let us assume everything was valid. Marriage was valid, nothing was illegal. He was valid son. Then also there was some reason that this particular provision existed in under old Akshara law itself, where very clearly it says that the full blood, half blood would that would be preferred.
अच्छा ठीक.
And whole concept of
Thursday.
Aksara is proximity
Thursday
to
ना
Yes.
पाठड़ है, हर केस को छोड़कर प्रायोरिटी देना. That is the law that we have learnt at bar. Parted matter in single bench has to be given priority even to a division bench. इसलिए जब केस कॉल आउट हो तो आ जाएंगे. यही है ना हमारे बार का नियम. यही है ना हमारे.
Yes, yes.
Orders item 6, second appeal 481 of 2016.
Yes, madam.
will also be a substitution issue under number 3476.
Whose substitution is this?
Appellant number 4, Manachu, who died on 30th/9/2024, which we have mentioned in para number 3. The name and address is mentioned on para number 4, Manachu, validation and delay is
Any
also
objection from the other side? There is one more respondent who has died.
ID number 3477, respondent number 6.
Notice has been issued to them. इनको पहले नोटिस कर देते हैं आपके सब्स्टिट्यूशन के बारे में. ऐसे नंबर 481 of 2016. ID number 3477 of 2025 has been filed. Substitution of deceased respondent number 6, namely Nirmal Mandal, who is said to have died on 23/9/2024. And there is also a prayer for combination of delay of 86 days in filing the intermediate application. The name of proposed legal heirs and successors have been given. In para 4, let notice be issued to the proposed legal heirs and successors of respondent number 6 for which requisites under ordinary process. They are from Jharkhand. For which requisites be filed within 1 week. Post this case on 10th of July awaiting service. 10th तक नहीं हो पाएगा. 17th.
Item 7, second appeal 133 of 2017.
For verifying the second IA, substituting the legal heirs, the parent just verify करना है वो
You file a response to it. So advised.
इंस्ट्रक्शन के लिए हम उसको अपना तो ऑलरेडी फाइल है, कौन अलाइव है नहीं है, 23 मेरा आपका फाइल, बाकी लोगों का.
Essay number 133 of 2017. The learned counsel for the parties are present. The learned counsel for the respondent prays for and is granted time to seek instructions with respect to IA number 6938 of 25. Post on next Thursday.
Item 8, second appeal 216 of 2018.
Yes. तो इसमें क्या है? Stay. Other side has appeared. Other other side has appeared, not appeared.
Notices have been served upon
रिकॉर्ड आया इसका? अभी एडमिट नहीं हुआ है। अभी तो डिले भी कंट्रोल नहीं हुआ है। Essay number 216 of 2018. Counsel for the appellant seeks adjournment. Post on 7th August.
Item 9, second appeal 248 of 2018.
this 2 weeks time. So I have to file for petition because respondent number 8 and 35 died. 8 died in 2011. He has been made party in the judgment and degree. Therefore, we have included him. Respondent number 35 died thereafter. And they have filed to counter affidavit. I have to reply that.
You have filed IA number?
I have filed number of files.
कौन सा IA का reply आपको फाइल?
For time, I have not filed IA. But
काउंटर एफिडेविट आपने किसका काउंटर एफिडेविट फाइल किया जो इतना परेशान हो गए?
हमने फाइल किया है कि 16 अपलेंट ही मर गया है और उसके 1150 दिन के बाद ही फाइल किए हुए हैं फॉर सेटिंग असाइड अबेटमेंट 91st डेज के बाद अब बिटवीन 150 डेज तो अपील तो ऑटोमेटिकली अवेट कर गया। अब नाउ क्वेश्चन रिमेन सेटिंग असाइड वो भी रेमेडी खत्म हो गया। अब ये कॉज जो देंगे कॉज बुजुर्ग को देखना है तो अपलेंट ही मरा हुआ है इनका। अब इसमें एक बोल रहे हैं रिस्पोंडेंट भी मरा हुआ है।
we have filed the limitation petition with the substitution petition
किसका सब्स्टिट्यूशन?
of the appellant.
अपलेंट
Sole appellant.
अपीलेंट का इसमें कुछ ऑर्डर ड्रॉप किए थे हमने पहले।
नोटिस हुआ
My lord has issued the notice with regard to all the petitions, IA petitions.
नहीं वो छोड़ दीजिए ना। अपीलेंट डेथ हो गया तो क्या हम लोग करेंगे इसमें? कब डेथ हुआ अपीलेंट?
2018.
कब? फाइल करने के पहले की बात?
नहीं बात in the month
हो
of
सकता है
December. Yes.
कब है डेथ सर्टिफिकेट कहाँ है? तो ये तो ऑलरेडी अबेट कर गया, अब क्या बचा है?
No, my lord. When await किया हमने फाइल कर दिया. Thereafter when I came to know that the appeal is pending here, the legal heirs, we have filed the limitation petition along with the setting aside abatement petition and
तो आपको क्या ऑब्जेक्शन है?
अब तो ऑब्जेक्शन है कि 1150 दिन के बाद ही
1125 दिन
आप तो जो राइट एक्रू किया लिमिटेशन सब जो राइट है सब तो जस्टिस ओरिएंटेड और सब्सटेंशियल जस्टिस डज नॉट बार द लिमिटेशन। तो जो अभी इतना दिन के बाद ये आ रहा है, ये कह रहे हैं कि हमको जानकारी ही नहीं।
नहीं हमको जानकारी थी।
यही इनका कॉज है कि हमको एडवोकेट
जानकारी थी।
केस फाइल किया ही है, आप कहते हैं कि एडवोकेट खबर किया था हमको जानकारी, यही इनका रीजन है।
केस तो ये नहीं ना फाइल किए,
इनके फादर किए थे,
फादर किए थे ना, हो सकता है बच्चों को जानकारी नहीं हो।
अब बच्चे उसी एड्रेस पर रह रहे हैं, अगर रिजाइडिंग डिफरेंट एड्रेस
अरे
पर
भाई बाप क्या क्या केस फाइल कर रहा है, सब बच्चों को जानकारी रहती
नहीं,
है
लेकिन
क्या?
हम इंग्लैंड अमेरिका से कहीं देखेगा तब उसी गांव
कोई
में
जरूरी नहीं है।
सब एड्रेस सेम एड्रेस पर आ रहे हैं। अच्छा इनका देख लीजिए
सेकंड अपील या पेंडिंग पड़ा हुआ है, आप उसमें आपको
हमने
application
कुछ
करना पड़ेगा।
इसमें कुछ नहीं करा। इनका एड्रेस भी देखा जाए, जो एड्रेस में एफिडेविट दे रहे हैं इनका सेल्फ एडिटिंग है। पैरा 4 में कहते हैं कि उसी एड्रेस पर देते हैं जहां पर फादर इनका, और एफिडेविट में डिपोनेंट दे रहा है दूसरा एड्रेस का। हाउ कुड ही डेयर टू फाइल फॉर एफिडेविट? उस एड्रेस का रहता ही नहीं है वहां।
He is having lot of property value. That cannot be wrong.
बोलते हैं भाई। आपका एक गांव में एड्रेस होगा, एक रांची में एड्रेस होगा,
हाँ ठीक है,
एक झारखंड हाईकोर्ट का
हाँ,
एड्रेस
हाँ,
होगा,
हाँ,
एक आपका चेंबर का एड्रेस
तो
होगा।
हर जगह कुछ ना कुछ चाहिए ना, कम से कम
हाँ
सिमिलेंस चाहिए ना।
तो आप क्या बोलते हैं?
तो कहीं कुछ नहीं है। ये
क्या यहाँ पे एड्रेस प्रूफ देना पड़ता
वो
है?
एड्रेस हमको मतलब ही नहीं है, वो लिस्ट का था। हमको सिर्फ दिखाना है कि ये बहुत रिलेटेड आए हैं, अभी कहते हैं नॉलेज नहीं है, इतना ही देखना है कि नॉलेज है, इनको सारा नॉलेज है। हम इस पर जजमेंट देंगे अपने।
क्या लिखे हैं कि आप सारा नॉलेज है? क्या आप ऐसा रिकॉर्ड पे लाए हैं कि इनको सारा नॉलेज है? ऐसे स्टेटमेंट?
ऐसा नहीं,
आप सरकार है ना?
सरकार का केस इसमें नहीं है, इसमें प्राइवेट।
अच्छा प्राइवेट।
हाँ
क्या ऐसा चीज आप रिकॉर्ड पे लाए हैं कि इनको नॉलेज है केस के पेंडेंसी के बारे में?
अब सन इज सपोज टू नो दिया है।
Supposed to know.
So अब बेटा कहे कि बाप क्या किया है हम जान ही नहीं रहे, ऐसा कैसे हो सकता है?
हो सकता है, हो सकता है।
हाँ, ये कहते हैं कि एडवोकेट हमको
अब बेटा क्या क्या करता है बाप को पता नहीं चलता।
ये तो कह रही, ये तो हो सकता है, बात सही है, लेकिन इस पर हम इतना ही करेंगे कि कहते हैं कि हमको
4:30 बज गया है, अगला हफ्ता ऑर्डर करेंगे इसमें। आपको अगर कुछ फाइल करना है तो कर दीजिए।
हम लोग फाइल
नॉलेज का डिनाइल के लिए आपको जो कुछ एफिडेविट तो फॉलो करना ही पड़ेगा।
That has been mentioned, categorically
ये
mentioned.
कहते हैं कि एडवोकेट खबर की।
Father, the original appellant was 92 years old. He was looking after the matter. The sons were not looking after the matter. Therefore, with whom the case is pending, he was not knowing.
देखिए आप एक फॉर्मल रिप्लाई उसका फाइल करें।
My,
84 से चल
जो
रहा
भी
है।
है आपको आपको बोलना है इंस्ट्रक्शन लेके फाइल करें। ऐसे नंबर 248 of 2018। Counsel for the parties are present. A petition has been filed for substitution of sole appellant who has expired, and there is enormous delay in filing the petition. The respondent has filed a counter affidavit.
I am representing
Opposing the-
2 to 5.
Respondent number 225 has filed a counter affidavit opposing the prayer for substitution and condonation of delay. Counsel for the appellant prays for and is granted time till 30th of June to file a rejoinder. Post on 3rd of July.
I'll give.
तो कितना ऑर्डर है?
Yes.
ये डिस्ट्रीब्यूट होगा, we will you'll get a date.